We had a few people missing. Let me see if they came in. Michael Castro. Michael Castro. You're here for? He's not here. Let us know if he gets here. He didn't announce earlier today. Luis Rodriguez. Okay, that's federal custody. Ryan Abrego. Ryan. Ruben de la Cruz. Saw Mr. Martinez. De la Cruz. Ruben, no. Darius Hartfield. David Ham. Your Ham? Okay, mark it down. Wait for your attorney. Jerry Villasano. Okay, that's you? Okay, and Jaron Yachtpot. Jaron. Yeah, that's you? Okay. All right, those three at the end showed up. Just wait for your attorneys to come. That's not the service. That's not the service.
Usually just be attached with the steps. I'm sorry. I already gave it to the judge. It's up there on the bench. Defense didn't want to sign it. So.
It's the manslaughter one, right? The plea hasn't come in yet. The plea hasn't come in. Yeah, the plea agreement, you're turning the steps?
Yes, Judge.
Oh, okay, I'm sorry. I thought you said something happened. Yes, sir. That's fine, because he's in the. So. And now the clerk's swear you're playing over there, so he's not to get up. Okay, both sides ready on state of Texas versus Andreen McDonald.
Stage right here. That's right.
Let me cover a few things before we start on this, what looks like a plea agreement. On 19 CR, where's the cert of appeal? Okay. He didn't sign the cert of appeal, he just signed it for the conviction on the manslaughter. I'm gonna hand it to your attorney if you want to approach it. You have a right, it's not a plea bargain, so you have a right to appeal. So this is on the conviction on the manslaughter. Thank you. And a few other things, on this case of tampering, let me put this over here, 19 CR 10910, the discovery acknowledgement, defense counsel still not going to sign this acknowledgement?
Same objection that we had before, Judge. In murder indictment, manslaughter conviction, 19 CR 10911. In addition to that, we had a motion to suppress that's filed in this case. They're kind of absolutely related cases. This was actually the first indictment. So I'd ask the court to take judicial notice of the testimony in the record in 19 CR 10911. And the motion to suppress hearing and the hearing and any related testimony related to both the motion to suppress and the motion to dismiss for one of the speedy trial. I ask the court to rule on those motions, and then we'd be prepared to proceed.
Any response on that? The state's okay with that?
Your Honor, the court already made rulings on that. I believe it's during the week of January 17th when the suppression hearing was heard. So we ask that the court respect those rulings. Okay.
On the motion to suppress, I'll take judicial notice of whatever everything counsel just asked, and I'll deny that motion to suppress. As far as the agreement here, it looks like it's
Oh, I'm sorry, Judge, the motion to dismiss for speedy trial.
okay. That's tonight also. Yes,
After taking judicial
I'll
notice.
take judicial notice on that too.
Thank you.
And Your Honor, sorry, we have one last housekeeping matter. We requested this in the murder indictment, but we would request again for written findings of fact and conclusions of law with respect to the denial of the motion to suppress. We would certainly accept if the court would just simply convert the same requested findings of fact and conclusions of law that have been sought in the murder indictment, if they could just be also entered in this cause number as well.
Okay, so you're asking, because I didn't hear you ask for that in the, or at least I don't remember you asking for that in the Manslaughter.
Yes, Your Honor. I asked for it verbally and in writing within the body of one of our motions.
Okay, I get that.
We would request that again here.
Okay. Let's see. Okay, state, any evidence on the tampering plea?
Yes, Your Honor. And the statement offers states exhibit number 1 and its attachments. And Your Honor, for the record, the state is proceeding on counts 2, 4, and 5. We waive and abandon count 1 and count 3.
No objection to the waiver and abandonment, Your Honor, and no new objections to the offered stipulated evidence.
Okay, they're admitted. Counsel, do you believe your client's mentally competent?
Yes, Your Honor, he is.
Okay, Mr. McDonald, you're a United States citizen?
Yes, sir.
Okay. How do you plead to counts? You can go ahead and stand up. How do you plead to counts 2, 4, and 5?
Guilty, Your Honor.
Okay, and it looks like you have to stay standing. It looks like the agreement is for 5 years TDC. There's no application for community supervision or deferred. And thank you. And there's a scratched out part here that's saying, I guess the part about voluntarily waiving his right to appeal. He's not waiving the right as far as suppression issues.
Yes, Your Honor, as to those matters raised and ruled upon by Your Honor.
Okay, okay. And in addition, I don't see it on here, but state filed a motion to stack the sentences or run consecutive. Is that, and tells the agreement that the defense is going to ask for concurrent and state's going to ask for stack?
That is correct, Your Honor. The state filed a motion last week seeking a cumulative sentence of the 5 years on the tampering on top of the 20 years for the manslaughter. We're going to argue that you do so. Defense will ask that it run.
I'm sorry, one more time, Stephen.
We're going to ask that it be stacked, and defense will ask that it run concurrent.
Is that your agreement, counsel?
Yes,
Did I take his plea? No, 2 for 4?
Yes.
You did? No contest or 50? Okay. All right, it's my understanding neither side has any witnesses.
The state has no witnesses. We'd only have argument.
No witnesses, Your Honor.
Okay, all right, go ahead and make argument. You can have a seat while they're making argument.
Yes, Your Honor. Just for the record, before I begin my argument, the state has talked to the family of Andreen McDonald in regards to the arrangement that we've reached today. The family would like to see this case come to an end. They would like to see some finality, so that they're pleased that the prosecution at this point is going to be concluded.
Okay, so they're okay with what's going forward as far as closure today, and they're aware of all the details of 5 years and either concurrent or stacked?
That is correct, Your Honor. We've explained to them that the possibility about going to trial, the risk, the pros and cons associated with that. We've talked to them about that. They are okay with it.
Okay, and I did mention something off the record. I want to put it again, is there's no other charge as far as the desecration of a corpse or tampering. I think the statute passed on tampering with a body or anything like that. This is kind of
Yes,
close
Your
out
Honor.
case.
The state did look into the abuse of a corpse statute under 4208, which is a misdemeanor. That statute has passed. We also looked into 3709, tampering with the human corpse, a second-degree felony. statute on that is 3 years, and that statute has run as well. So we do not see any other cases that this conduct we anticipate going forward on Mr. McDonald.
This should finish it as far as all are concerned.
And that's the defense's understanding of the agreement. What we're doing here today is that this represents finality for any of the state's prosecutions for this event.
Okay, State, you the chief.
And yes, sir. And now in terms of our argument as to why the court should do cumulative sentences, of course, the court heard this trial, the murder trial, in which the jury returned a verdict on manslaughter. The egregious nature of this case, all the tampering aspect that Mr. McDonald did was an intent to try to deceive the court, an intent to try to deceive the jury, trying to cover his actions and causing the death of his wife. Specifically, what we have the torn up receipts on the items that he bought from Lowe's, in which the defendant on the stand admitted that he was going to use those items to chop up his wife's corpse. Also, the hammer that he said that he used to strike his wife multiple times that he claims out in the field off of Speck Road. Also, the clothing that he was wearing, trying to make sure nobody could see him, the dark clothing, the shoes, a hoodie, some jeans, to try to cover himself and make it harder for anybody to see him. Again, Your Honor, all of this was an attempt to try to deceive and try to cover up his actions in this case. Based upon the egregious nature of what was conducted, we feel that stacking a cumulative sentence is appropriate in this case. We'd ask that you stack the 5-year sentence, or that first you impose 5 years on the tampering, and then stack that sentence upon the 20 years that you received on manslaughter. Thank you.
Thank you, Counsel. Defense.
Your Honor, the defendant's trying to accept responsibility, and everyone's making that as difficult as they possibly can. And I understand why, and the court understands why. But that state's argument I heard made in front of the jury as you did, and they rejected it. What about some respect for the jury? They did not find murder. They found him not guilty of murder. They found him guilty of manslaughter after the court gave them an Allen charge after they were out for 12 hours of deliberation. So now we have a 3rd-degree felony tampering charge with a few counts in it, which the court has to run together to one 5-year sentence. And the only issue for the court is whether you're going to stack it on the maximum sentence that you gave him for manslaughter. That's kind of, I don't know, it's the system saying we don't care if you accept responsibility. There's even this lingering idea that nothing's ever enough. Paul Anderson stood in this courtroom and said, I love you. I feel like I lost one child and I forgive you. And those are the same people who've kind of blessed this deal. I'm not going to take up a lot of time. It's totally your decision as to whether you stack it. But the better lesson for people to come forward, take responsibility, and for respect for the jurors, would just say, no, you get the 5, you get tagged for that, you get an additional felony conviction for someone who heretofore didn't have one, and you know all about his life, and that's enough. That's fine now.
Thank you, Counsel. I will note, obviously, it's another felony charge. This was y'all's agreement that y'all came to. He was obviously looking at, I'm not in part of any negotiations. He was looking at the 10, and this is something y'all came to, so that's obviously in what I'm considering. Okay, Mr. McDonald, you can stand. Okay, I will tell you, I'm not going to speak as long as I did last time because you heard what I had to say. And I know there's got to be some good in you because of the life you lived as a father prior to this. And sometimes good people make bad or huge mistakes. And you were Air Force major, had no criminal history prior, but I also hope I just didn't think of it till I looked at my calendar and I was doing emails. We're 13 days away from when you killed your wife and mother of your child. And I hope you think about that on the 28th of February coming up and every day that you're in prison. It's not, tampering is never a 3G, so it's going to, parole-wise, he's aware of that and stuff. Okay, I am going to go ahead and stack your sentences, run them consecutive, sentence you to 5 years, TDC, the Institutional Division of Texas Department of Criminal Justice. I've got to put this for the record. It's going to run after the manslaughter case number 2019 CR 10911. It's a conviction for manslaughter in the 399 District Court, Bear County. The date of that manslaughter conviction was February 6, 2023, and that sentence was for 20 years. Right, good luck, Mr. McDonald.
Your Honor, we would ask that the court give him credit for the time that he served in the Bear County Jail.
Yes, he'll get credit for the time. Okay. Thank you. Thank you, counsel.
Thank you, Judge.
Do we be excused, Your Honor?
Let me give, if counsel can approach and get a cert of appeal. Get him a copy.